So the delay was due in part to audio issues in my courtroom, which happened not even half an hour ago. We had to move. I thank my colleague for letting me use her courtroom. In a minute, Lisette is going to hand you jury instructions because both sides have rested. You're going to read along with me. I have to read it into the record. It's easier, I think, if you absorb the information as you follow along with me. A copy of the jury instructions will be sent back to you as you deliberate, so you don't have to memorize anything in these instructions, but please pay close attention to them. And I'll tell you which page number I'm on as we read along together. There's 2 instructions that I need to read to you as part of the evidence. Number 1 has to do with parental rights. It's also part of its instructions. The court has taken judicial notice that there are no records in Miami-Dade County terminating the parental rights of Pedro Jimenez. Also an instruction on the use of transcripts. Someone had asked about transcripts. There is a copy of transcripts that will be available to you, but it is an aid to what you view in the evidence being the statement of Ms. Link that was already introduced into evidence. So you heard a recording and you will be furnished transcripts of the recording. The recording is the evidence. The transcripts are provided to you only as a guide to help you follow. And I'm sorry, as you listen to the recording, the transcripts are not evidence of what was actually said or who said it. If you notice any difference between that and what you hear on the recording and what you read in the transcripts, you must rely on what you hear and not on what you read. All right, so I'm going to read a paragraph and then we're going to start with the jury instructions, and then the lawyers will have an opportunity to make their closing arguments. Both the state and the defense have now rested. The attorneys will now present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening and a rebuttal argument after the defendant has spoken. All right, I'm on cover page of the instructions. Members of the jury, I thank you for your attention during this trial. You have now heard all the evidence in the case. In a few minutes, the lawyers will present their final arguments. First, it is my duty to instruct you on the rules of law that you must follow and apply to arrive at a proper verdict. I'm on page 2. Daisy Link, the defendant in this case, has been accused of the crime of second-degree murder with a firearm. Introduction to homicide on page 3. The defendant is accused of the crime charged in count 1 of the information of 1 count of second-degree murder and manslaughter, all of which are unlawful. However, a killing that was excusable homicide or that was committed by a justifiable use of deadly force is lawful. If you find Pedro Jimenez was killed by the defendant, you will then consider the circumstances surrounding the killing in deciding if the killing was second-degree murder or manslaughter, or whether the killing was excusable homicide or resulted from the justifiable use of deadly force. Justifiable homicide. The use of deadly force to kill a human being is justifiable homicide and therefore lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in or upon any dwelling house in which the defendant was at the time of the killing. Deadly force means force likely to cause death or great bodily harm. Great bodily harm means harm that is more than slight, trivial, minor, or moderate. Excusable homicide. The killing of a human being is excusable homicide and therefore lawful under any one of the following 3 circumstances. 1, when the killing is committed by accident and misfortune and doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3, when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. I now instruct you on the circumstances that must be proved before the defendant may be found guilty of second-degree murder or any lesser included crime. Second-degree murder. To prove the crime of second-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. Number 1, Pedro Jimenez is dead. 2, The death was caused by the criminal act of the defendant. 3, there was an unlawful killing of Pedro Jimenez by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. Lesser included crimes. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which she is accused, there may be evidence that she committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crime indicated in the definition of second-degree murder with a firearm is manslaughter. Page 6, the definition of manslaughter. To prove the crime of manslaughter, the state must prove the following 2 elements beyond a reasonable doubt. Number 1, Pedro Jimenez is dead. 2, the defendant intentionally committed an act or series of acts that caused the death of Pedro Jimenez, or the death of Pedro Jimenez was caused by the culpable negligence of the defendant. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, which caused the death. I will now define for you culpable negligence. As I have said, every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to do harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care towards others. For negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard of human life or grossly careless disregard for the safety and welfare of the public. The negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant knew or reasonably should have known was likely to cause death or great bodily injury. 7, page 7, aggravation of second-degree murder or manslaughter by carrying or using a firearm. If you find that the defendant committed second-degree murder or the lesser included offense of manslaughter, and you find beyond a reasonable doubt that during the commission of the crime she personally carried or used the firearm, you should find her guilty of second-degree murder or the lesser included offense of manslaughter with a firearm. A firearm is defined as any weapon, including a starter gun, which is intended to or may readily be converted to expel a projectile by the action of an explosive, the frame or receiver of any such weapon, any firearm, muffler, or firearm silencer, any destructive device, or any machine gun. The term firearm does not include an antique firearm unless the antique firearm is used in the commission of a crime. If you find the defendant committed second-degree murder or a lesser included offense of manslaughter, but you are not convinced beyond a reasonable doubt that she personally carried or used the firearm, then you should find her guilty only of second-degree murder or the lesser included offense of manslaughter. Justifiable use of deadly force on page 8. It is a defense to the crime of second-degree murder, including the lesser included offense of manslaughter, if the actions of the defendant constituted the justifiable use of deadly force. Deadly force means force likely to cause death or great bodily harm. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm. The defendant does not have the burden of proving that she was justified in using deadly force. Instead, for you to find the defendant guilty, the state must prove beyond a reasonable doubt that the defendant was not justified in using deadly force. The law on justifiable use of deadly force is as follows. Defendant was justified in using deadly force if she reasonably believed that such force was necessary to prevent A, imminent death or great bodily harm to herself or another, or B, the imminent commission of burglary or false imprisonment against her or another. If the defendant was not committing any crime, other than the alleged second-degree murder or any lesser included crime for which the defendant is claiming self-defense or defense of others, and if she was in a place where she had a right to be, then the defendant had no duty to retreat before using deadly force. On the other hand, if at the time the defendant used deadly force, she was committing second-degree murder or manslaughter, or if at the time the defendant used deadly force, she was not in a place where she had a right to be, the defendant had a duty to retreat. The duty to retreat means the defendant had the legal obligation to use every reasonable means to avoid danger before using deadly force. The law does not require the defendant to retreat if she was placed in imminent danger of great bodily harm or if she was placed in imminent danger of death or great bodily harm, of imminent danger of the commission of burglary and or false imprisonment against herself and or others, and it would have increased her own danger to retreat, or if retreat, it would have been futile. But if the defendant had a duty to retreat and she could have safely retreated, but did not do so, then her use of deadly force was not justifiable. If the defendant was in a dwelling or residence in which she had a right to be, she had no duty to retreat and had the right to stand her ground and use or threaten to use force, including deadly force, if she reasonably believed that such conduct was necessary to prevent imminent death or great bodily harm to herself or another, or B, the imminent commission of burglary or false imprisonment against herself or another. Burglary is defined as follows: entering a dwelling owned by or in possession of another, and at the time of entering the dwelling, the unauthorized person had the intent to commit the crime of false imprisonment. Dwelling means a building of any kind, whether such building is temporary or permanent, mobile or immobile, which has a roof over it and is designed to be occupied by people lodging therein at night, together with the enclosed space of ground and outbuildings immediately surrounding it. The enclosure need not be continuous, as it may have an ungated opening for entering and exiting. For purposes of burglary, a dwelling includes an attached porch or attached garage. False imprisonment is defined as follows: to forcibly or secretly confine or abduct another person without lawful authority to do so. Secretly means the defendant intended to isolate or insulate. Secretly means the victim in this case, Pedro Jimenez, so that's a typo, intended to isolate or insulate the defendant and or the minor child and or the minor children from meaningful contact or meaningful communication with the public. I'll repeat, that was a typo. So secretly means the victim in this case, Pedro Jimenez, intended to isolate or insulate the defendant and or the minor child and or the minor children from meaningful contact or meaningful communication with the public. Confinement of a child under the age of 13 is against the child's will if such confinement is without the consent of the child's parent or legal guardian. In deciding whether the defendant was justified in the use of or deadly force, you must consider the circumstances at the time the force was used. The danger need not have been actual. However, to justify the use of deadly force, the appearance of imminent danger must have been so real that the defendant actually believed the use of deadly force was necessary. Moreover, to justify the use of deadly force, a reasonably cautious and prudent person under the same circumstances must have believed the use of deadly force was necessary. The defendant is presumed to have held reasonable fear of imminent peril of death or great bodily harm to herself or another when using defensive force that was intended or likely to cause death or great bodily harm if the person against whom the defensive force was used in the process of unlawfully and forcefully entering or had unlawfully and forcibly entered a dwelling, residence, or occupied vehicle, or if that person had removed or was attempting to remove another against that person's will from the dwelling, residence, or occupied vehicle, and B, defendant knew or had reason to believe that an unlawful and forcible entry or unlawful and forcible act was occurring or had occurred. The presumption of reasonable fear of imminent death or great bodily harm does not apply if A, the person against whom the defensive force is used has the right to be in or is in a lawful resident of the residence, such as an owner, lessee, or title holder, and there is not an injunction for protection from domestic violence or a written pretrial supervision order of no contact against that person, or the person or persons sought to be removed as a child or grandchild, or is otherwise in the lawful custody or under the lawful guardianship of the person against whom the defensive force is used, or C, the person who uses defensive force is engaged in a criminal activity or is using the residence to further criminal activity, or D, the person against whom the defensive force is used is a law enforcement officer who enters or attempts to enter a residence in the performance of his or her official duties, and the officer identified himself or herself in accordance with any applicable law, or the person using the force knew or reasonably should have known that the person entering or attempting to enter was a law enforcement officer. A person who unlawfully and by force enters or attempts to enter another residence is presumed to be doing so with the intent to commit an unlawful act, force, or violence. Dwelling means a building or conveyance of any kind, including any attached porch, whether the building or conveyance is temporary or permanent or mobile or immobile, which has a roof over it, including a tent, and is designed to be occupied by people lodging therein at night. Residence means a dwelling in which a person resides either temporarily or permanently, or is visiting as an invited guest. Vehicle means a conveyance of any kind, whether or not motorized, which is designed to transport people or property. If you find the defendant who, because of prior threats or difficulties with Pedro Jimenez, had reasonable grounds to believe that she was in danger of death or great bodily harm at the hands of Pedro Jimenez, you may consider this fact in determining whether the actions of the defendant were those of a reasonable person. On page 11, in considering the issue of self-defense or defense of others, you may take into account the relative physical abilities and capacities of the defendant and Pedro Jimenez. Parental rights. This court has taken judicial notice that there are no court records in Miami-Dade County terminating the parental rights of Pedro Jimenez. Instruction on edited recording. You heard our video recording. The court instructed you that the recording had been edited to eliminate irrelevant portions that would not add to your understanding of the case. The fact that the recording had been edited should not concern you in any way and must not impact the way you view and listen to and consider this evidence. Transcripts of recordings. During this trial, you heard a recording and you are now being furnished transcripts of the recording. The recording is the evidence, and the transcripts are provided to you only as a guide to help you follow as you listen to the recording. Transcripts are not evidence of what was actually said or who said it. If you notice any difference between what you hear on the recording and what you read in the transcripts, you must rely on what you hear and not on what you read. Plea of not guilty, reasonable doubt, and burden of proof. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation and the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, and the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. Page 13, weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence you should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than others. You should consider how the witnesses acted as well as what they said. Some things you should consider are, did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? Has the witness been offered or received any money, preferred treatment, or other benefit to get the witness to testify? Had any pressure or threat be used against the witness that affected the truth of the witness's testimony? Did the witness at some time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of the expert's testimony. You have heard the testimony of a child. No witness is disqualified just because of age. There is no precise age that determines whether a witness may testify. testify, the critical consideration is not the witness's age, but whether the witness understands the difference between what is true and what is not true, and understands the duty to tell the truth. The defendant in this case has become a witness. You should apply the same rules to consideration of her testimony that you apply to the testimony of other witnesses. It is entirely proper for a lawyer to talk to a witness about the testimony of what the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or testimony of any witness. Defendant's statements. Statements claimed to be made by the defendant outside of court have been placed before you. Such statements should always be considered with caution and be weighed with great care to make certain they were freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statements were knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to whether the defendant made the statements, she had been threatened in order to get her to make them, and whether anyone had promised her anything in order to get her to make them. If you conclude the defendant's out-of-court statements were not freely and voluntarily made, you should disregard them. Rules for deliberation. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice, and there is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you have heard from testimony of the witnesses and have seen in the form of exhibits and evidence in these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. And the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the defendant has been proved guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and the law contained in these instructions. And deciding a verdict is exclusively your job. I cannot participate in that decision in any way, so please disregard anything I may have said or done that made you think I preferred one verdict over another. Page 18, verdict. You may find the defendant guilty as charged in the information or guilty of such lesser included crime as the evidence may justify or not guilty. If you return a verdict of guilty, it should be for the highest offense which has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. Only one verdict may be returned to the crime charged. The verdict must be in writing, and for your convenience, the necessary forms of verdict have been prepared for you, and they are as follows. It's pretty simple. Page 2 is the date and the jury foreman. You don't have a copy of this, but I'll hold it up. So it's really a one-pager. You have 3 choices: not guilty, guilty of manslaughter as a lesser included offense, or guilty of second-degree murder. If you find Ms. Link guilty of any of the crimes, there are interrogatory findings regarding the firearm. So you have to make a finding for the manslaughter. If she actually used the firearm, yes or no are your options. Similar options for second-degree murder. You'll have the options of whether or not she actually possessed the firearm during the commission of the offense. Also options of yes and no. You'll then go to number 2. Did she discharge the firearm during the commission of the offense? Then you'll go to number 3. Did she discharge the firearm causing death during the commission of the crime? It's pretty self-explanatory. And as I said earlier, the lawyers will have an opportunity to make their closing arguments to you. The state gets to go first. And for the state, we have.
May I please report?
Yes.
Counsel. Ladies and gentlemen of the jury. On June 25th, 2022, Pedro Jimenez was murdered. He was murdered by his 9-year relationship, his spouse, his wife, his defendant, Daisy Link. Earlier that day, Pedro Jimenez was picked up by friends. Ms. Link knew that. And he went over there and was there for a very long time. And that made Ms. Link angry. He wasn't home. He wasn't spending time with her. or his children. He was with friends. He's a trucker. He's never home. Why aren't you spending time with me? Her mother's there. Her children are home. Her mother flew in for a barbecue. Why aren't you spending time with me? And so what does she tell her mother? I'm going to go pick this idiot up. He's probably drunk off his ass. And she goes. She's not afraid. She goes there, unafraid, uninvited. And she waits outside, and minutes pass. And she asks Pedro, where are you? And he doesn't respond. And so she goes inside to look for him, unafraid, not scared, uninvited. And she sees him, and he says, I'm coming, I'm coming. And she pulls him out of the house and takes him home. Their home. Not her home, but their home. And then they go and get beer. And they continue acting like a family, a toxic family. No doubt about that. We were the first ones to tell you it was a toxic family. We're the first ones to speak. We're the last ones to speak. It is our burden. But we were very upfront with you, ladies and gentlemen of the jury. This is a toxic relationship. Two people that should have never been together. Ms. Link said Pedro Jimenez was a good guy. I disagree. I don't think he was a good guy. But he didn't deserve to be murdered that day. And so they fight. Why? Because Pedro has his suspicions. He accuses her of cheating. He's never home. This is his wife of 9 years. And he accuses her of cheating. And she denies it. And they continue fighting. And then he backs off. And he accuses her again. And they fight about that. And then he backs off. And they continue fighting. Over and over again. Until Pedro gives up and leaves. Miss Link already had the gun at that point. And she goes outside to smoke her cigarette. And Pedro comes home. And she sees him. And she says, you know what? I'm done with this. You're never home. You're not around our kids. My mom's here for a barbecue. Which, mind you, happened earlier that day that he missed. You know what? You're right. I did cheat on you. And what does Pedro say? She's holding the gun at that point. He says, as she's pointing the gun at him, do it. Do it then. I want to die. I gave you everything. His voice drops and he turns and starts walking away. And then he realizes, as the gun is pointing at him, that Miss Link is serious this time. We heard that they were a toxic relationship. He hit her just like she hit him. And he started to run. And she fired. And it went through his foot in an upward manner through his thigh, hitting his ephemeral artery. Pedro had cocaine in his system, yes. He had alcohol in his system, yes. He had marijuana in his system, yes. But we heard from Dr. Mathis that coke actually kept him alive. He would have died faster. And so what does Daisy do? She mocks him, belittles him. It's not like I hit a major artery. You'll be fine. A couple seconds pass. As he's running away, fleeing from her, he's the one in fear. You sure you don't want to go to hospital? No? Okay. And then she tosses the gun. She goes back to where she shot, and she picked up the casing that was never found.
Objection, fact not in evidence.
So this is argument of what the lawyers believe evidence showed you. You should rely on your memory of what the evidence was. You can continue.
And then Daisy realizes, wait, my neighbors heard that gunshot. Let me go see where Pedro is. And she goes looking for him. And she doesn't call 911. And she finds him. And he's laying on the ground. He had been running, hiding in bushes, scared. And she finds him. And what does she do? She goes up to his body as he lies there dying, begging for help, asking her, pleading her, call 911.
Objection, facts not in evidence.
Sustained.
And she goes through his pockets, takes his phone, takes his identification, and walks back to the car. And she hides that stuff because she doesn't want anyone to know who he is. Because if they find out who he is, they'll figure out she was the shooter. And so finally she walks back and starts rendering aid because she realizes what's about to happen. He's about to die. And so that is the time that she calls 911 and she lies to the 911 operator. She says, I have no idea who this person is, despite being married to him for 9 years. I don't know what his date of birth is. I don't know how old he is, despite being married for 9 years. I just found this random man. I was walking around in the alley, despite being married to this man for 9 years. Officers arrive and she asks, Pedro, what happened? What the fuck happened? She knew, and she lied, and she lied, and she lied. Officers were kind to her. They let her go back to the home. This is a spouse. She's scared. They didn't know what was going on at that time until Detective Danny Morales shows up, seasoned homicide detective, and he sees a woman in the middle of the area. He doesn't know who she is, and he approaches her, and she becomes aggressive. In fact, that night she threw a chair at him. And so he detains her, and as he detains her, as he pats her down, trying to calm her down, trying to get a hold of the situation, she starts hiding the keys in her pocket. The keys of that same Chevrolet Trax with Pedro's stuff in it that would identify him, that would link her to this crime. Eventually, they bring her to the homicide headquarters. She never denies that they lived together, never denies that he lived there, never denies their relationship. Changes her story over and over and over again. Listen to it. It's an hour and a half long. An hour and a half of changing statements, of changing stories, giving more detail, taking that detail back. We gave you a transcript as well. Read it over. She changes her story over and over and over again. Officers find a firearm, that same firearm that belongs to her. The same firearm that she used to kill Pedro. And that night they arrest her, but that's not where their investigation ends, ladies and gentlemen of the jury. They continue investigating. They find surveillance video that disproves what Daisy Link was saying, that shows Pedro fleeing, hiding, in fear. And they take it back and they try to download it. And because of the program, when it gets plugged back in, it gets deleted. And that's a shame. But it wasn't deleted on purpose. We heard the steps that they took to preserve that evidence. And old technology is old technology. But this defendant murdered Pedro Jimenez that night. So as we heard jury instructions read to you earlier, there are some rules of deliberation about how you should weigh the evidence in this case. And I want to walk through these 8 rules with you all and talk about the state's witnesses first and how you should weigh this evidence. Number 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? Yes. Every single state witness was personally involved in this case or was there the night of the murder, investigated the case, talked about what they did. Each and every state witness didn't say, well, I wasn't there, I don't know what was going on. Everyone was there. Every state witness testified to that. Kevin Bonilla was at the house when Daisy showed up and walked inside to go pick Pedro up. All the detectives were on scene. canine officers who found firearm. Everyone there saw and testified to what they did. Did the witness seem to have an accurate memory? Yes, they did. It's 3 years ago, sure. But they remembered what they did. They remembered their investigations. Was the witness honest and straightforward in answering the attorney's questions? Yes. This is a trial. There are objections. Some are sustained, some are overruled. Absolutely. But not a single state witness gave a sarcastic comment. Not a single state witness argued. Everyone was very candid with what they did, what they didn't, what they remembered, and they were honest and straightforward the entire time. Did the witness have some interest in how the case should be decided? No. 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 Does the witness's testimony agree with the other testimony and other evidence in this case? Absolutely it does. And we'll walk through the evidence in a few moments, but absolutely it does. Each step officers took agreed with the next step. They talked about how homicide teams work in teams, that there is a lead. That lead gives assignments. The blood trail is consistent with the video that Mr. Cisneros saw, that Detective Morales saw, that Detective Hubbard saw. It's all consistent. Has the witness been offered or received any money for treatment or other benefit in order to get the witness to testify? No, we heard nothing of that. Nothing. Had any pressure or threat been used against the witness that affected the truth of the witness's testimony? No, we heard nothing of that. Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Not really, no. They weren't handed a deposition transcript saying, didn't you say this a couple of years ago? Absolutely not. Absolutely not. So when you're viewing the state's evidence, use these rules. When you're thinking about the state's witnesses, use these rules. Importantly, as we heard, as I talked about, as we have all talked about, my burden in this case, I have to prove this case to you. It is my job and my job alone to prove this case. My burden is a reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. That is my burden. Just like we talked about in jury selection. If it's wet outside and we heard thunder and it's wet for miles and miles and miles, it is reasonable to believe that it rained. It is not reasonable. We have to imagine, speculate, force ourselves, pretend that a fire truck came and sprayed it for miles and miles and miles. That doesn't happen. A reasonable doubt as to the guilt of the defendant may arise from evidence, conflict of the evidence, or lack thereof evidence. And that's a really important point. And we'll talk about that in a little bit. Now, as the judge read, as you have in your hands, second-degree murder, and we talked about this in a little bit during jury selection. What do I actually have to prove? What are the elements of second-degree murder? Number one, Pedro Jimenez is dead. Number two, the death was caused by the criminal act of dangerously. And number three, there was an unlawful killing of Pedro Jimenez by an act imminently dangerous to another and demonstrating a deprived mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design and purpose. An act is imminently dangerous and demonstrating a deprived mind if it is an act or series of acts that a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, is done from ill will, hatred, spite, or evil intent, and is of such a nature that the act itself indicates an indifference to human life. And importantly, I do not have to prove intent that she wanted to kill him that night. If it meets those three elements, in order to convict of a second-degree murder, it is not necessary for the state to prove the defendant had the intent to cause death. Merely these three elements. So let's talk about these three elements and how the state proved beyond a reasonable doubt these three elements. The first, as you heard, ladies and gentlemen of the jury, there is a stipulation in this case. Pedro Jimenez is dead. There is no disagreement there, and you must take that as true. So the state has proven beyond a reasonable doubt the first element. We're a third of the way there already. 2 and 3, the death was caused by the criminal act of Daisy Lane. and there was an unlawful killing of Pedro Jimenez by an act imminently dangerous to another and demonstrating a deprived mind without regard for human life. I'm going to take these two together. I think it's important to talk about these two together. And importantly, we can talk about it. There was a lot of testimony about what the timeline is, when they found a gun, when they didn't find a gun, when Daisy admitted to the crime. The timeline is really important. June 25th at 3:06 a.m. A Ring video starts recording. At 3:11, a gunshot is heard. Daisy tells Pedro, "It's not like I hit a major artery. You'll be fine." Couple beats. "You sure you don't want to go to the hospital?" "No, okay." No fear, no adrenaline like she testified to, nothing. Calm as a cucumber. If you pay attention closely to the right-hand side, you actually see Pedro fleeing. Adrenaline, fear. Nothing. Cavalier attitude. Anger, hatred. Pissed off as hell. Not adrenaline, calm. And discuss Pedro's statement before she shoots. Do it, do it. I want to die. I gave you everything. That is a man who is broken by his wife of 9 years. It is not him charging at her. It is not him screaming at her. This isn't an assisted suicide. This is, you're pointing a gun at me. Nobody says, do it, I want to die, while there's a gun below you, hanging off the side. This is a man who has a gun in his face, steps away from this defendant. Do it then, do it. I want to die. I gave you everything. You broke my heart. You just told me you're cheating on me. This is a toxic relationship with domestic violence going back and forth. And you know what Miss Link did? She lit a match and lit that fire that night because she wanted this relationship to be over. And this was the best way to do it. This was a broken man. Maybe a drug addict, never home, not really seeing his kids all that much. A broken man. He just found out that his wife was confirming his suspicions the entire time. 3:21, 10 minutes pass. Daisy Link calls 911 and lies about who he is, who she is, everything else.
Today, June 25, 2022, 03:21 and 57 seconds.
I have a detective for fire, what is the emergency? Right, yeah, I don't know why I can hear about freaking, okay, Donald, I want you to check the phone to see where you are. Do you know what happened to him?
I have no idea. He's bleeding everywhere.
Is he awake and breathing? And let's place here at 1300. 18 highway down. Where? Where? Are you in Homestead now? Yes. What is the phone number you're calling from? 9656095939. So that you guys don't send police to another call, fire is already from.
Lie after lie after lie after lie after lie. 3:27, 6 minutes. 6 minutes after she calls 911, Officer Nicholson arrives first on scene, and she lies to him. And what does she say to Pedro, despite knowing exactly what happened? Pedro, what the fuck happened? She knows. She shot him. She pointed the gun at him and discharged it as he ran away. What the fuck happened, Pedro? I shot you is what the fuck happened. Officer Nicholson asked, Pedro, what happened? And she says, if you listen closely, I hit a major artery. Listen to it carefully. This is his body worn camera. She says, I hit a major artery. That's an admission, ladies and gentlemen of the jury. She shot and fired. And it links up directly to her statement earlier, where she mocked him. It's not like I hit a major artery. She knew what she was doing. She was aiming that gun on purpose. This is not a ricochet. It didn't hit the ground, bounce up. She shot it at him as he fled. We actually see Pedro Jimenez's last breaths ever. We watch him die. His last moments on earth. His wife pretends he didn't know that she murdered. Victim pronounced deceased at 3:40 a.m. Officer Rodriguez speaks to the defendant, who again lies to him. He left in a van. I don't know who his friends are, despite going there earlier in the day and picking him up. The van that officers wasted precious time searching for. She sent them on a wild goose chase. Later on, homicide detectives arrive. 5:40. 6:30. Daisy's sister shows up and says, well, if he's dead, Daisy did it. She knew. She knew. But she knew that it was a toxic relationship. She knew that Daisy hit Pedro and Pedro hit Daisy. That Daisy was going to light a match eventually. She knew. Between 6:50 and 8:30, Detective Cruz canvasses the scene of Pedro's murder. They walk the scene, they take photographs, they try to figure out piece by piece what's going on. They don't find a gun. 9:20 a.m. when the defendant enters the room. That's how aggressive she is. I'm not putting that shit on. Covered in blood. Angry.
If there's no one on the person, I gotta see for that,
I'm not putting that shit on. She even goes on to say at 3:52 in that hour and a half video that you have in evidence, why are you treating me like I did this? Why are you taking pictures of me like I did it to him? She says at 4:08, the bruises are from a car accident, which she confirmed, by the way, on the stand when I was cross-examining her yesterday. She says the bruises don't apply to this, trying to make it seem like he would hit me. Lie after lie after lie after lie. At 12:27, canines locate a firearm. I'm sorry. At 12:27, a residential search warrant is executed for Daisy and Pedro's home. And what do they find, ladies and gentlemen? Look closely. Men's shoes, men's clothing, adult men's clothing. Pedro lived there. It was his home. Same time, canines locate a hidden firearm. Hidden firearm. That was about the only honest thing she said that night, that she hid that gun. And it was her gun. And it's not until 3:39, 4:20 that the defendant begins her hearing. We know that, not just because we heard it and we can see it on video. The time of when she waived her Miranda rights and chose to speak to officers is actually memorialized on that Miranda form itself. You have the right to remain silent. You don't have to talk to me if you do not wish to. You don't have to answer any of my questions. Do you understand that right? Yes. Should you talk to me, anything which you say may be introduced into evidence against you. Do you understand? Yes. If you want a lawyer to be present during questioning at this time or any time hereafter, you are entitled to have a lawyer present. Then, yes, you cannot afford to pay for a lawyer, one will be provided for you at no cost if you want. You understand that right? Yes. And then she waives. She voluntarily spoke to them. It says a lot of very interesting things during this statement. But I think what's most interesting here is her demeanor during this. She's crying, she's sad, she's scared, until she's confronted with one of her lies. And you can actually see her demeanor change. She's not scared anymore. She's mad. You see her demeanor change when officers catch her in a lie. What if I have you on video saying, it's not like I hit a major artery, you'll be fine? Her change in demeanor is important here. What else does she tell us? I was angry. Doesn't say I was scared. Not talking about something that happened 5 days ago. I was angry. What did she say about the shooting? One of the 5 different stories she tells that night and yesterday as well.
It was down, and then once he said, oh, you're gonna sleep outside tonight, bitch. That's when I used to spit it up and I just cocked it and I shot it, it was already cocked and everything. I shot it.
Catch that? It was already cocked. He says, you're sleeping outside. I lifted it and I shot. It was already cocked. She was outside, not scared. Her with the deadly weapon. We know Pedro never had the gun. We know he never had a weapon. She said as much. At 5:03, when she tells officers where the firearm is. 5 hours prior, though, K9 already had located it. She wasn't being helpful. They already found it. They were already piecing the picture together. As she's being interviewed, they're doing their work. They find this ring camera. They find the firearm. They're doing their job. They're watching video. The defendant is eventually arrested that day, and then on June 26th, a secondary canvass is conducted with other K9 officers. They don't find him. They don't find the casing. The casing that Daisy Link hit, because she didn't want to get caught. We also know, based off the subsequent search, Pedro's path that night. Well, let's talk about this. We heard not from 1, not from 2, not from 3, but 4 officers about that video footage at Robert Cisneros' house. We heard from Robert Cisneros himself. It's an older model DVR. It's plugged in, it's hardwired. I saw it with my own eyes. I saw the victim running hiding behind bushes, running and then collapsing. A woman passing by, going to his body, manipulating his body, walking away, coming back. We actually can piece together his path based off the evidence. The CSI photos, the blood spatter. We know that Daisy's house is where he got shot. I'm sorry, Daisy's house. This is the porch. What's important is those two doors. She said that he was charging at her while she was on the floor. Where? How? That's what she tells us. And after he gets shot, he runs this way. We know that from the blood spatter. Daisy walks this way. You'll be fine. Not like I'm gonna be. Not like I hit a major artery. You'll be fine. And he continues running. And we actually see that in that same video. And blood spatter continues. We know, again, that he travels up through the alley until he gets to this car. Blood spatter again, before collapsing and dying. Right? And look at where the Chevy tracks is. Look how far away it is. Daisy would have had to have walked feet after feet after feet to get to him and hide his stuff back in the car. It took her time. It was deliberate action she was taking, but she didn't want to get involved. And we can also piece together Daisy's path that night as well. This is their home. She shoots and fires. He's running away from her. She goes this way, the trampoline. She says, not like I hit a major artery. You'll be fine. Beep, 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 beep. You sure you don't want to go to the hospital? Ah, you'll be fine, okay. And then she comes back and she hides the firearm. Her firearm. She has to come back, get in her car, and drive. And she waits. She doesn't call 911. There was just a gunshot. She knows she hit him. She doesn't think she hit him where she hit him, but she knows she hit him. And so she goes to look for her husband of 9 years. She's not afraid of him. She's not scared of him. She's not thinking about an incident that occurred 5 days prior. This is a toxic relationship, and she just lit the fuse. I cheated on you. You're right. You're never home. So she says, my husband of 9 years, I just shot. Let me go find him. You can't take back a murder. Her rendering aid, attempting to render aid, lying officers. Lying officers are relevant. Rendering aid is hero. You can't take back a murder. She goes, and she goes this way, up, and back. We know she doesn't go this way. There's a car lot. You know, it's not this way. It's her car and it's over here. And it's important. She goes this way, up, and she walks over to Pedro's body, turns her car off, and takes his items out of his pocket. His phone, his money, his keys. She goes back and starts running her gate. It took her time. These are deliberate steps that she took. The shot itself. He was running away. His foot out through his ankle, and then through his thigh. In, out, in, out. It was a clean shot. It was a good shot. The only way that shot makes sense with one shot, from what we heard from Dr. Mathis, is when somebody is running away. That's the trajectory that it took. That is the only way that that is possible. And if it missed the foot, it's still going through the thigh either way. It's still hitting that artery either way. This didn't bounce off the floor through his foot, ricocheting, and then ending up in her thigh, or his thigh. It was a good shot. Again, we can see Dr. Mathis' work. Entry, exit, entry, exit, through the femoral artery. And how do we know that it was Daisy's gun? Pay attention. Pay very close attention. Earlier in the day, we get back to the shot. What's in her hand? The firearm she hid. She got that gun. It was her gun. How do we know it's her gun? Well, we heard from criminalists from the Miami-Dade Crime Lab that they tested it for DNA. And the majority of that DNA belonged to none other than the defendant, Daisy Link. And how do we know that? The statistic they came up with. 1 in 28.71 septillion that it is her DNA. Septillion is 24 zeros. That's not a small number. The population of Earth is 8 billion. That's 24 zeros. It's her gun. Talk about reasonable doubt again. And this is so important because I'm about to talk about the defense witnesses. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. A reasonable doubt as to the guilt of the evidence of the defendant may arise from the evidence, conflict of evidence, or lack thereof evidence. And what's important here, ladies and gentlemen of the jury, there's actually no reasonable doubt for the state's evidence. But when you look at conflicts of the evidence, you should also take a look at the evidence that the defense presented. And to be clear, they don't have to do a single thing. Her attorney never has to open his mouth. I'm the only one that has to do anything. But they gave us interesting evidence, interesting testimony. And you weigh that evidence, that testimony, the same way you weigh the state's evidence. Did the witness seem to have an opportunity to see and know the things about which the witness testified to? Absolutely not. Absolutely not. We heard from her niece, Laylin, who lives in Texas, who flew to Florida 4 days prior. And what did she do? Well, I went to my aunt Crystal's house and we hung out. And then there was a barbecue a couple of days later. And I saw some injuries to Daisy, but I can't tell you where those injuries are from. I don't know what day it was taken. I wasn't there the night that he was killed. Wasn't there when he got shot. She wasn't there. We heard from Crystal. Same thing. Same thing. And she even admitted she didn't know if Pedro lived there or not. Crystal pretended like she knew. Excuse me, Laylin pretended like she knew, but she was challenged on that. You're not coming in to Florida often. You live in Texas. You don't know. It's entirely reasonable to believe that when Pedro comes home, your aunt's not telling you, hey, my husband's home. She has no idea. Her mother testified as well. She left. They said it was such a dangerous situation, she left her grandchildren with such a dangerous man. She watched her daughter get choked, nearly murdered in front of her, and she leaves? It's one thing to say, I can't control this 30-year-old person. If they want to do what they want to do, they're going to do it. It's an entirely different thing, though, to leave an 8-year-old and a 5-year-old in that situation. Because it didn't happen. Did the witness seem to have an accurate memory? No. Crystal denied making a statement to Detective Morales, but then challenged. She goes, well, actually, they're confrontational. I think Crystal even said, how would I know? I'm not safe. Did the witness seem honest and straightforward in answering the questions? Absolutely not. Same thing. Crystal said, I'm not a psychic. How would I know? Well, it's your sister, right? Shouldn't you know about her abusive husband? You know about the toxic relationship. You know she hits him and he hits her. But you're not a psychic. You can't put one and one together. You know your sister has a gun. I just showed you it's her gun. Did the witness have some interest in how the case should be decided? Does the witness testimony agree with the other testimony, other evidence in this case? Has the witness been offered or received any money for fear treatment or other benefit in order to get the witness to testify? Had any pressure or threat been used against the witness that affected the truth of the witness's testimony? Let's talk about Pedro Jr. for a second. And his testimony being so critical. What did he tell us? I'm here to get my mom out of jail. Here to get my mom out of jail. I live with my grandma. I talk to her at least about this case. I make it up. I forget. What happens? Sometimes I say daddy shot twice 5 days before, but no, grandma wasn't there, mind you. Corrects me. If they're willing to coach a child on what to say, it is very reasonable to believe that they have been coordinating their testimony to. They weren't there, they don't know. And a child has admitted. Children are pretty honest. And honestly, Pedro Jr. seems like a great kid. Really honest. He said, when I make a mistake about the night, that my grandma wasn't there. She tells me what happened. She wasn't there. How does she know? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Absolutely. How many times did they get impeached with their own depositions? Let's talk about the lease agreement. Now, this is an older one. And I want to bring to your attention 3 major things here. Tenant's email address, pete89.pj@gmail.com. Phone numbers. Top right, my copy. My copy, not original. Not that, not filed one, my copy. And then right here, where it says Daisy Lane, pay very close attention to this line. What does that look like? That looks like whiteout. My copy. As you make it out, you can actually kind of see Pedro Jimenez's name right underneath it. But that's consistent with being whited out on her copy, not the original, her copy. Let's talk about the newest lease as well. Defense Exhibit D. Well, ladies and gentlemen, the jury. Pedro's name's not on here. You know it's also not on here? Any signatures? How do we know? This wasn't updated. There's no initialing. There is no signatures, no dates, no times. How do we know? Let's talk about earlier in the night. They said the family tossed an evil man. I'm sorry, actually, let me back up. They said he was a good guy. That's what she said. He was a good guy. Not the family, though. They came to rescue her, but they waited for days. They were there, they were working barbecue. They flew in the middle of the night. They left their grandchildren. Earlier that day, Daisy picked Pedro up on her own volition, mind you. Pedro holding a beer. Who shows up? His children, her children, their family. They are a family. No fear. Not being scared. They are a family. Even later, the victim returns to the car. Probably left some stuff in it. After all, he rented that vehicle. Who walks back to the car with Pedro and Daisy? I showed you this a few minutes ago. Pay attention to what's in Daisy's hand. A gun. That same gun. Her gun. Daisy told us an interesting lie yesterday, and her mother did too. That was completely refuted by actual evidence. They said that Pedro punched through a wall and opened this door. Well, good thing we have photographs. Tell me where the broken window is. Even if he punched through that. Look, I'm not the biggest guy in the world. I don't believe in superheroes. I don't think Pedro is Mr. Elastic. He can't open that door from there. There's no broken window. There's no punch window. That didn't happen either. Lie after lie after lie after lie. Another really important thing. Let's talk about what happened 5 days prior. I believe something happened. Hell, we have pictures. I absolutely believe something happened. But not what Daisy said. Pedro Jr. was coached on what to say. How do we know that? Well, Daisy actually told us. She has cameras. They record things. That would have happened on or about the 20th or 21st. And what's really interesting here is the conveniences. It is really convenient. We have the 18th. We have the 22nd. And then the night of the murder. This is from her phone. Isn't it convenient how that video doesn't exist? Isn't it convenient? What actually happened that night, ladies and gentlemen of the jury? Actually happened that
That's what.
That's what happened. She was mad as fuck. Pedro's never home. On the road all the time. Off getting high. I was mad as fuck. Ladies and gentlemen of the jury, state has proven beyond a reasonable doubt the death was caused by the criminal act of Daisy Lane. She pointed the gun that we already pointed at and we made those statements. So he fled, he ran, she fired. She actually made a very surprising omission yesterday when she said that she didn't think she was going to hit him. She pointed and fired with purpose. That yesterday, contradicted by her own statement, which is full of its own contradictions over and over and over again. I didn't think it was going to hit. It is proven beyond reasonable doubt. Element 2. Element 3. There was an unlawful killing of Pedro Jimenez by an act imminently dangerous to another and demonstrating a deprived mind without regard for human life. Pointing a firearm and shooting it is imminently dangerous. Deprived mind, I don't know what's more deprived than after you shot someone, mocking them. You'll be fine. Not like I hit a major artery. You'll be fine. After breaking this man's heart and lighting that fuse. Talk about lesser. Oh, let me back up. After the state has proven element 1, element 2, and element 3, state has proven beyond a reasonable doubt that the defendant is guilty of second-degree murder. As you heard, there are lesser included offenses in this case. Lesser included offenses are offenses that make up the actual charge, but they're smaller. There's less there. And as you heard, in this case, it's manslaughter. What do we have to prove for manslaughter? That Pedro Jimenez is dead. That we all agree. You have to take that as true. We all agree. 2, Daisy Link intentionally committed an act or acts that caused the death of Pedro Jimenez. She lifted the gun. She pulled the trigger as he ran. That is an act that caused the death. We heard Dr. Mathis say, cause of death, manner of death, homicide, gunshot wound. Daisy Link did that. I've already proven to you, beyond a reasonable doubt, that this is a second-degree murder. But I've also proven manslaughter as well. Aggravation of a firearm by aggravation of a felony by carrying a firearm. This is important too because you will have a verdict form that you will have to make certain decisions on. If I've proven my case, you must make the determination beyond a reasonable doubt that Daisy Link actually possessed the firearm during the commission of the crime. She's admitted that. Whether the state has proven beyond a reasonable doubt that Daisy Link discharged the firearm, she's admitted that. Whether the state has proven beyond a reasonable doubt that Daisy Link discharged the firearm and in doing so caused death or great bodily harm to Pedro Jimenez. He's dead. Proven that. This is really important too. Justifiable use of deadly force. Self-defense. That's what this case is. That's the defense that they have put on. The defendant was justified in using deadly force if she assumed reasonably that such force was necessary to prevent imminent death or great bodily harm to herself or another, or the imminent commission of burglary to a dwelling or false imprisonment against herself. I'm not going to talk about those because there's no evidence of those. But let's talk about imminent for a second. I had a conversation with Mr. Cruz during jury selection. I threatened him, remember? We were at Publix in the line. I cut him. He said some words to me. I said, I'll see you outside. I lifted my shirt. I showed him my gun. Imminent. It is happening right there, right then. Not 5 days before, not hours before, right then, right there. There was a lawyer on the panel who mentioned a bus 200, 300, 400, whatever it was, feet away. And he said, that is imminent. No, it's not, because there can be an intervening cause. Car accident. Imminent, right away. So as the judge showed you, your verdict form will look a little like this. I couldn't fit in the signature line for the foreperson in the data time, but this is what you'll get. This is something you'll get. And you're going to have to make a decision here. Guilty of second-degree murder, guilty of manslaughter, or not guilty. Well, again, I've proven my case beyond a reasonable doubt. So check off second-degree murder. And as we talked about already with the aggravation of a firearm, she did actually possess a firearm. She did discharge a firearm, and she did cause death. That's what your verdict form will look like, ladies and gentlemen of the jury, because there is only one verdict in this case that is consistent with the evidence, consistent with the facts of this case. And the only verdict that justice demands, and that's this defendant, Daisy Link, is guilty of second-degree murder. Thank you.
Thank you. And now for the defense.
Can we take a quick comfort break just so I can get set up?
Sure. Why don't we do this? Why don't we go to the jury room for a few minutes and we'll come back out and then we'll do the other closing.
All right, for the jurors, once you step down, those jury room is on.
Give them time that tell the state how much time they will. What? 50 minutes. Thanks. So we have 52 minutes. Okay. That's fine. You're keeping time now. All right, folks, we'll be back in a few minutes. Thanks.